attending this presentation. So welcome everybody. Introducing Justice Annette Horst of the Manitoba Court of King's Bench, Family Division, who is here to talk in a way that will be beneficial in a practical way to everyone with respect to advocacy skills from her perspective from the bench. So thank you again, Justice Horst, for being willing to make this presentation. I will, without further ado, let you get started.
Thank you so much, Rebecca, first of all, for inviting me in the first place and for that wonderful introduction. Welcome, everyone, to our Advocacy Skills Judicial Perspective. My intent today is not to tell you everything you might need to know, but certainly at the end, I'm happy to answer any questions and we can have some discussion, but to give perspectives and highlights of advocacy skills in the circumstances where I have, as a judge, found that there are perhaps tips and tricks that might be of assistance to you. So we're going to move to the next slide. For the purposes of today's presentation, when I speak about advocacy, I do include both written and oral advocacy. I think that depending on your personal strengths, people might gravitate towards one or the other, which I completely understand. And you'll see later in my presentation, I do encourage that. But you do have to remember that there are two components and to make the most of both of them. I'm also going to talk a little bit about trial specifically, obviously, but also motions, what to look for with the judge themselves, what are judges looking for, how to manage self-represented parties, which is certainly a significant component of trial work and motions work and practice in general, and some trial procedure and rules of evidence. There won't be a lot of evidence, just sort of highlights of significant issues that I have noted in trials before me. So turning next slide, please. Starting with written advocacy, because that's where you generally start. You've started with a brief, and that is your first opportunity to present your client's case and to begin to influence the decision you want the judge to make. A brief should include all of your points. So my best example to you is that I read the briefs before I come in the courtroom to have an understanding of what the case is about and to have an understanding of what it is you're asking me to decide and what is the law. But you need to include the salient facts from your client's perspective. You should include a complete statement of facts, but you shouldn't hold something back. Too often I see this occurring where someone is, they say, this is what I want. Okay, great. Why do you want that? And they don't explain the why. They don't have any information in their brief about why what they want is the correct decision. So I come into the courtroom and I say, based solely on the statement that that's what I want, I don't see the basis for that, potentially. And then they start to say, well, but there was this happened and this happened. It is almost a way of reducing your own credibility as an advocate, because the appearance that you're giving is that you've held things back in the hopes that maybe the judge would just agree with you off the front end. And then when they don't, you're throwing mud against the wall potentially. So in your brief, put forward all the relevant facts, put forward all your relevant arguments. You're not giving anything away. You should have had discussions with opposing counsel. Everybody should know where you disagree. So this isn't, trial by, ambush or argument by ambush. So clearly, what is the argument you want to make? And make sure that your brief puts forward all the information to support that argument. Because if you don't, you risk significantly, in my view, an adverse inference, essentially, against your client. Let's go to the next slide, please. Which brings me to the affidavits. So affidavits are very much a form of written advocacy. They allow you to control the evidence in a way that when you're having oral testimony, you do not have. It allows you to put into evidence the facts that support your case. So you need to know what your case is. What is the argument I want to make? What evidence do I need to support that claim or argument? And that's what should be in the affidavit. I cannot say this strongly enough. Do not let your client write the affidavit. They are providing you the evidence, the information, but you should be drafting the affidavit. I can tell that a client has been intimately involved in an affidavit because it contains hearsay, opinion, largely irrelevant material about the hurt feelings of the affiant, about what the other person has done to them, why they feel aggrieved, not the facts and evidence that would allow me to evaluate the legal issue that they're asking to put before the court. It is very difficult, I understand, particularly in family law, to explain to a client what is relevant and what is not. They want their hurt feelings. They want the issues that are emotionally important to them to go into the material. But you need to be able to say to them, this is why that is not relevant. And in those circumstances, they also need to understand if they are doing that, if they are putting in material that is highly irrelevant and just appears to demonstrate that they are too emotionally involved in the issue, the court again can find that they're not putting forward their best evidence. It's not necessarily relevant, and it can adversely affect their case. Hearsay is allowed in affidavits, but you must always state the source of the information. Or in Manitoba, we've moved away from striking affidavits as a procedural issue. It is still very much something that the court can do, and you can request that it be done, but it will be disregarded, whether it is struck out or not. And largely, I see it most commonly when clearly the client has had too much say in what's in the affidavit. They'll say, I was told. They don't say who told them. They don't say when they found out or how they found out. And, you see third, second, or third, fourth removed. My cousin told me and he heard it from his neighbor. You need to control that. As I say, hearsay evidence is permitted in affidavits, not for trial, though. Interestingly, I think it's important to remember that. If you're arguing a motion and your affidavit says, I was informed by and do verily believe that, that's fine. But for trial, it is your personal knowledge only and not hearsay. And the use of affidavits at trial is being more and more encouraged, certainly in Manitoba, and I think in other jurisdictions as trials have taken on a life of their own as far as length and duration, the amount of time that they're taking is a way to streamline. And so it's important that if you're doing trial affidavits, that there is no hearsay in them to make the affidavit useful and relevant for the court's purposes. Next slide, please. Thank you. So the affidavit should not include argument. That's for your brief. Again, your client's affidavit shouldn't say, I think, or I believe about the legal issues. That's their argument. And it should be just the facts, not their opinion. I think that he will cheat on me again. Okay, so first of all, whether your spouse cheated on you or not is irrelevant. And secondly, your opinion about it is not something the court is concerned about. All right, next slide, please. So what should you be looking for from the judge? And I believe I have two slides very similar on this same point, because I think that this is something that I was certainly taught in law school, and I'm not sure if it's still being taught or if it's just sort of a lost art form. But the first thing is, if a judge asks you a question, you should answer it. I have frequently heard counsel say, or I will come to that. Okay, that's theoretically good in the sense that you are going to come to it, but I'm going to be thinking about my question and you're going to keep talking. And I just need to know the answer to that question, because then it will help perhaps guide me through the rest of what you're saying. When I ask you a question about a specific issue, that's what I'm concerned about for my decision. That's what in the evidence I'm struggling with. I'm having trouble piecing it together. And I think that that's important to know. I understand it's difficult when you're interrupted. You've sort of thought about what you want to say. Perhaps you've written it out. And it may be difficult to sort of answer immediately what that question is. But I think it's important, because if you don't, you run the risk that the judge stops thinking about anything that you're saying. And they can't move beyond that until they have an understanding. So I think that you need to be able to sort of adjust in and answer those questions as they're raised. So if the judge stops writing during your argument, and they put their pen down, and they sort of fold their hands, and they're watching you, and this is a pretty big signal that I think a lot of counsel miss. Certainly, self-reps don't understand what this means at all, but this means that I'm still listening to you, but I'm not likely being persuaded by what you're arguing. And if I interrupt and I say, I have your point, I could mean that I have your point. I'm fine, but moving on is really what I'm looking for. Next slide, please. All right, so you're going to trial. We do spend a lot of time, particularly I think in the courts generally, certainly in family court, making every effort to settle matters. However, sometimes a trial is necessary, and you need to work through that process before it actually starts. And so I think some old advice is still relevant. Things like don't ask the question you don't know the answer to, unless you absolutely must to get the evidence in. Don't ask open-ended questions in cross-examination. I recently did a trial, and I had junior counsel, which I appreciate that part of the way you learn to do a trial is by actually doing a trial, where I, on a number of occasions, intervened, and the lawyers were clearly getting frustrated that the witnesses were not giving them the evidence that they were looking for. And it was on cross-examination. And so I intervened and I said, you understand on cross-examination, you can put the answer to the witness. You know, I suggest to you, isn't it true that, in that nature? Because they were doing essentially direct, trying to ask open-ended questions on cross-examination, which is a really good way to let the opposing witness or party not tell you what you want to hear. So you do want them to be able to agree with you, yes or no. I have seen, unfortunately, some counsel get very aggressive in this circumstances. So they ask the witness a question, and the witness has said yes or no, and then the witness wants to go on to explain their answer. And the lawyer has said, no, that's fine. Nothing, yes or no. And unfortunately, you do have to let the witness have the right to answer more fully if they choose. So you should avoid cutting them off. It's not necessarily, the explanation is not necessarily going to make the answer different or worse for you if you've got at least you've got the answer at the front end that you actually want. Don't lead your witness in direct unless it's on uncontested facts and you have permission from the judge. So at the start, say, Your Honor, my lord, my lady, justice, judge, however you're addressing the court, may I have permission to lead the witness on uncontested facts? But make sure it's uncontested, because if the other side pops up in the middle of something and says, well, that's actually an issue in dispute, you're going to have a problem. But there's nothing wrong with the parties usually have, by the time they've got to trial, they have agreed, when they separated, hopefully, unless the trial is about that date of separation, they've agreed they have children, things of that nature. So then next slide, please. So where do you start in preparing for the trial? I would suggest to you that start at the end. Start with drafting your closing argument. What do you want to be able to argue at the end of the trial? This will allow you to consider what evidence you want to put in a trial. And I also think if you don't know where you're going, you will get lost, and so will the judge. It may sound strange, but if you sit down and you actually think, what is the question that I'm wanting the court to answer for me? So in a parenting proceeding, I want the judge to find that the best interest of the children is this particular parenting arrangement. And I guess I'm not necessarily suggesting you have to fully flesh out your entire closing argument, because it will be obviously influenced by the way the evidence goes in. But understanding what it is you want to be able to argue at the end will help you organize the witnesses that you need, and understand whether or not evidence is particularly relevant, because sometimes we get lost in the witnesses and what they're there for and what we think they're there for, and we lose sight of where we're actually going. And I have too often sat and listened to witnesses and at the end thought, I have no idea why that person was called, which is why, next slide, please, you need to start with your opening statement. I don't know anything about your matter when I come into the courtroom at the beginning of a trial. I've had very limited material that that's been agreed that I'm going to read in advance. I have a memo from the pretrial or case conference judge that sets out the issues, but may or may not set out, the positions of the parties, such as, parenting is at issue, mom wants X and dad wants Y. I may not know any of that. So an opening statement is your opportunity to tell me, the judge, what is your case about? What are the legal issues? And it flows from your opening to your closing naturally. At the end of the day, you want to be able to argue about what these issues are. What do you want me to decide? What does your client want? Too often, people have made grandiose statements in their opening, which is fine, but they didn't make any statement about the issues in this case are parenting time, child support, property division, and within those headings, determination of incomes. And so you get to you want the judge to know what they're supposed to be thinking about. It's completely appropriate to tell me who the witnesses are going to be. We're going to be calling 3 witnesses. My client will testify, a family assessor and, the school teacher. And they will all be testifying in support of the position that this is the parenting arrangement that's in the best interest of the child. So why are they being called? It is difficult for self-reps in particular, and it is an adversarial system to sort of focus, and for the clients generally to focus on who are the best witnesses for the case that they want to make. So you need to, that's why it's so important that you clearly identify what are the issues and set them out at the very beginning, so that you don't have a situation where nobody knows what this trial is about after it's over. Next slide, please. So this is where I want to talk about the witnesses. I've sort of touched on that already, but do you need the particular witness? People will talk a lot about, well, this is a character witness, trying to make my client look better. So if they're coming to talk about your client's parenting ability and you haven't seen your client for months, years, they're not particularly helpful to me. They can come and say that your client is, a great mom or a great dad or a great parent generally, and that when they saw them last year on summer vacation, they helped with the wiener roast, but like this is a larger issue than that. Your client will want to call many witnesses. They will all say the same thing. I think it's important to remember you can use an affidavit, and if it's not controversial, or if the other side's like, well, okay, you can do things by affidavit or by agreed documents. I have received many volumes of text messages between the parties. I've received, letters from doctors. So you can, if you can agree, put that evidence in very simply, and then you can just do cross-examination on those witnesses. And I think that this is the next point here. If your client's mom isn't going to say something nice about them, no one will. So when they say, I want my mom or my dad or my grandma or my grandpa to come and say that I'm a great parent, I mean, consider the source. Are they impartial? Is it necessary? Is it relevant? It's also because realistically, the judge is going to be, not entirely impressed that your own mother says that you're a great mom. One would hope that you also think she was a great mom. So that's just something that I always consider. If there's a specific incident that occurred and she was the witness to that incident, that's an entirely different story. But if you're calling the parents just simply to say they're great parents, I wouldn't expect anything different. And it may be the easiest way to do that is just to have an affidavit saying that. And then the other party might even say, you know what, I'm not even going to cross-examine them, because of course they're going to say that they're great parents. It is okay to agree to facts and documents to reduce the number of witnesses. In a number of trials recently, parties have argued about work schedules, and they've called in employers to vary that or to verify the dispute between them. You know, professional people, doctors, pharmacists, teachers. I think it's important to consider, is there a way to get the information that the parties are disagreeing about before the court in a different way? But when you are filing a document, so such as a letter, be sure that you understand that what is it that we're agreeing about this document? Are we agreeing that the document itself is true, or is it just that this particular document exists? This is a letter the teacher wrote, yes, but we don't agree with what she said. And she's going to come and be cross-examined on it. Next slide first, please. So who goes first? I'm always a little surprised that everyone isn't sure at the beginning of a trial. So usually the plaintiff or the petitioner or the applicant, it's their case, they started it, so they will go for it first. There are some instances where an onus is reversed, and the other party may go first. However, there are cases, certainly in Manitoba under our Domestic Violence and Stalking Act, the person who brought the application is the respondent, who was the party who wants to set it aside. And the applicant who got the protection order, we asked them to go first because they're entitled under the legislation to give further evidence than what they gave at the original hearing. And so that's an interesting example of where the person who started it doesn't go first, and the person who doesn't have the onus is still going to go first. And then I have also had experience in cases where one party is self-represented, and we've determined that it would be the most efficient use of court time and the most productive way to resolve the issues by allowing the self-represented person essentially to be the responding party, even if they were the petitioner. And so it really, you know, there's, like everything else good in law, there are rules and then there are exceptions. And the who goes first, I think, is a good example of that. Next slide, please. So when you are going first to trial, where do you start? So with your client, I have recently seen, and again, for every good rule, there is an exception, but your client would testify to all the issues. You don't get to break up the case. Certainly, we will, in certain instances, take professional witnesses out of order due to their availability. So a family court assessor or a doctor that's being called, and we will address that at the beginning. And that's why it's important to identify who your witnesses are, to identify any issues right off the start. We would like to call the child's pediatrician, for example. They're only available on Wednesday. In the trial, that's second or the third day of trial. And, you know, your client may not have completed their testimony, but we're still going to take that person out of order. And so that's important to think about. So your client, back to the point, if your client must testify to all the issues. So the rule in Brown and Dunn, and I'm going to be completely frank with you as a group and say that I'm not sure that I entirely understood this rule myself until I was actually sitting as a judge, and it became much more evident of what it was. So this is an evidence rule, and you must put to your client the version of facts that you want to contest before you put it to the other party. So too often, particularly with self-reps, what I see is they don't ask the first person any questions, and then they testify about a completely different factual version, and the other party hasn't been given the opportunity to dispute that. So then we have to recall witnesses, or we have to completely exclude all of the evidence. So it's important to know, and again, when you're thinking about your case, where are the issues? What am I going to be contesting? And make sure that you put these things to your client first, so that when you're having the opportunity to cross-examine the other party, you can say, So you heard my client testify that this occurred, and I put to you that that was in fact what happened. And they'll say, no, of course not. What I'm telling you is absolutely the truth. But to establish that record where both parties have addressed the issue. It's often interesting. Clients get flustered on the stand. There's nothing really we can do about that as lawyers and judges. We try to I'm sure, but having your client know and understand what you are asking. Clients get very, and also that they don't need to understand why necessarily they are being asked a question in cross-examination. Too often I see witnesses get into an argument. I don't know why you're asking me that. Okay, well, that's not the point. So they need to be prepared and understand that they have to answer the question, whether they know why it's being asked or not, because the other side has a theory of the case. You have a theory of the case, and that's where the questions may not seem intuitive to your client. So this is something I put in recently. I was doing a trial, and at the very end of the direct, the lawyer said, "Is there anything else you would like to tell the court?" And then the client immediately proceeded to tell me all of the evidence that had to that point not been before me as to why an asset was in fact shareable that he did not want to share. And this sort of goes back to the old rule. You shouldn't ask questions you don't know the answer to. You shouldn't let your client hang themselves. It's basically what this rule is. So they will hurt their own case. They're not doing it on purpose. But I can see the lawyer's face fall, and it's because just not giving that extra opportunity for the client to just give me a soliloquy as you speak about what they think. Next slide, please. So in addition to your client, there are additional witnesses. So I've spoke a bit about this, but with respect to experts, first of all, you have to really think about, is an expert actually necessary? And you have to think about, is the expert giving an opinion that is actually the decision of the court? I've recently had a matter where one of the parties said, well, you have to accept the expert's report. I don't actually, just in case there was any doubt about that. The expert's opinion is just that, their opinion, and it is one piece of evidence the court may consider. But in some instances, what the expert is, their opinion is really the decision that the court is being asked to make. So you may have obtained that opinion to help with settlement, right? If somebody frequently, family assessments, parties go into it with the idea that if the assessor recommends a particular parenting plan, then that's what we'll go with. And then, of course, they change their mind. But the assessor's view or the expert opinion is really just one piece of evidence. The other thing is to really think about, are they qualified to give the particular opinion that you want them to give? So in a circumstance where we're determining income for spousal support purposes, and you have a doctor coming to talk about whether or not the person is capable of working more, or if what they're doing, the doctor really may not have the ability to give an opinion about the person's ability to work. But that doesn't mean they can't give me the evidence about the person's medical condition, and then you can argue that medical condition is affecting their ability to work. And they may themselves say, since I was diagnosed, this is how going to work has been for me. So I know that obviously medical evidence is important in a lot of cases for a lot of different reasons. I don't want you to walk away and say, well, we should never get medical evidence. Absolutely, you should. And certainly in instances where, is someone capable of working, the doctor should be able to tell you about the particular condition that they've diagnosed, how that could affect that person. But they may not, they may be unable to say that they'll never be able to work. So then in addition to experts, then we of course have third-party witnesses. We've talked a bit about that already. Calling your mom, your neighbor. Did they see something? Like, what are they contributing? If they're there to say that your client's a great person, I often question the relevance or the necessity of that evidence. I wanted to also put here that records, business records, police records, CFS records can also be their own kind of witness. There are, of course, Evidence Act provisions with respect to business records. Often they go in as agreed documents. But when you put something in as an agreed record, you have to also advise the court as to the purpose that you want them to make of it. You should refer to it probably in your opening and in your closing as to why that they have it. Please don't just file records and never refer to them again. They are evidence once they are filed. The court has to read them and they have to consider them. And if I don't know why I'm reading them or considering them, really begs the record of, bears the question, why did you file them? So the best example I can give is I received once bound volumes of financial records and text messages, and 2 or 3 pages were referred to. I had to read all of them, but and they may have contained things that the parties didn't intend for the court to consider, but once they filed them as evidence, a court is required to consider them. Next slide, please. Which brings me to the point of an agreed statement of facts. I don't think that these are used often, and that's fine, but I think that you're doing yourself a disservice if you have a limited amount of trial time if you don't consider an agreed statement of facts. So think about what is agreed. If as I say here in the slide, don't bother if all they agree on is their names. If they're fighting about, we never met, let alone lived together and separated. I mean, but if they agree on substantive facts that go to the issues to be decided, then consider using an agreed statement of facts. It can be long, it can be short, but it could just essentially tie together historical facts that they agree on. We were married, we separated. It could be things like financial things. I make this much money. Here's my tax return. She makes this much money. We've always been employed in the same jobs. These are our children. This is where they go to school. So I think it's important. Sorry, I see there's a question about, I thought that now it's gone. Let me just open the chat. I thought that character evidence was inadmissible unless it was brought by the opposing party. So I sit in the family division. I should perhaps have, and people will often call witnesses on the premise that they're there to talk about parenting time. And then all the witness is describing effectively is that the other person is a good parent. I've I've seen them at soccer games, which is, in my view, essentially a type of character evidence. It's not that it's inadmissible in the family context because it's structured around the issue of parenting time. If you're talking about in the criminal context, I believe you are correct. And so but I'm not going to speak to that as I don't sit on those matters. So turning back to the agreed statement of facts. But remember again, and because we frequently see people having this disagreement at the first morning of trial, if it is agreed, then it is evidence and I can rely on it in making my decision. And you don't need to call other witnesses or provide the other documents to prove it. So be sure that they are in fact agreed, because, and this would be an important document to have your client read and say, do you agree to everything in that, for those purposes. Next slide, please. So an agreed book of documents is another important tool that I think, and I know people struggle when they have, like, do I want to put this in? Is it appropriate to put it in? I don't think you should just file volumes and volumes of material. I want to be clear about that up front. But I too often have seen people who struggle to file financial records as the best example. These are my tax returns. Well, both sides should agree that they should have exchanged that information, and they should have, you can just file them as part of an agreed book of documents in advance. That's my best example. But also, you can also say in your agreed book of documents, we're filing these documents 1 to 10, we agree to the truth of their content. 10 through 12, we're going to be there. We're filing them so the court can read them in advance, but we do not agree as to the truth of their content, and there will be witnesses called to talk about that. What an agreed book of documents does for you is allows you to basically have the material before the judge in advance. When you file large volumes of documents during the course of the trial, and we just keep going, think about that you know what it says, but the judge doesn't have time to stop and read it. I mean, a single page at a time, even sometimes, is a lot. If you're doing rapidly, here is your pay stub, here is your letter from your employer, here is the ROE, and none of these documents individually is significant. But if you're either taking a lot of court time or you are going to be talking about them in a way in advance of the judge actually having to take the time to read them. So I would suggest letting something go in that is not contentious. If the parties agree that they own a piece of property, filing the land titles documents. If they agree that they have a mortgage, filing their mortgage statement. Then neither one of them has to talk about it. If the issue is these are our assets and these are our debts, but we can't agree if something's divisible or shareable, then what I need to hear from the parties why they don't, like, what is the evidence as to why it's not shareable, as opposed to we're fighting about whether it exists at all. The last point about if you file it, it's evidence, and please refer to it. I think I've already commented on this a bit, but I just want to say it again. If you file a large book of documents and during the course of the trial, you refer to 2 of them, I still have to read all of it, and I'm going to be questioning why I'm reading it. So it's very helpful during the course of the trial to please, go through the documents, not necessarily for the purpose of authenticity or to identify them, but to make sure that the trial judge is aware of why they've read them. Some of them will be self-evident. If there's an issue of income for child support purposes and you've attached 10 years of tax returns, and there's an issue of child support going back 10 years, that seems pretty obvious to me. But if you've attached 20 pages of text messages because the parties both take the position that the other one is causing the conflict, and here's the text messages to show that, it would be helpful if, you perhaps confirmed that, who was who in the text chat, and highlight specific issues, because otherwise I'm going to read through all of it. And I would also caution you just generally about text messages and emails. Most people think they have a smoking gun and they don't. Next slide, please. So hearsay is something that everyone struggles with. And particularly self-represented parties don't understand the rule of hearsay. And for every rule, as we've said already, there are many exceptions. So if your client or another witness is describing what they saw or personally experienced, or are they just saying what they were told by someone else? Obviously, if they personally saw it, personally experienced it, that's their evidence. But if they just say, well, I heard from the grocery store after I got there that there was a big fight, that's hearsay. If there is an exception to the hearsay rule, then it can be admissible. Please don't be afraid to object to hearsay when you hear it. I have sat in trials and was of the view that the evidence being presented was hearsay. If I have self-represented parties, I may intervene, but if both people have lawyers and no one is saying anything, I'm of the view that you're conceding essentially that I should consider the evidence. Not to say that I will necessarily give it a lot of weight, but you're letting it in. In family law, the most common hearsay that I hear is what the children have said to mom or dad, or a parent. I don't want the children coming to court, so please don't take anything I say today as an indication that you should be getting children to swear affidavits or coming as witnesses. So it is generally acceptable to the court that, if dad says, well, they told me they want to live with me, mom is going to say, well, they told me they want to live with me. We're not, we are required when considering parenting time, to consider the wishes of the children and how best to receive that. Frequently, we have an assessor who the children have made statements to, and the assessor has reported that to us. It's still technically hearsay, but it is an admissible form. And to be clear, though, just because I accept that the children may have said something to your client or to an assessor, again, doesn't mean that it is going to be accepted as the outcome in the matter. Next slide, please. So again, this may seem like pretty basic information with respect to documents. All the evidence to be relied on a trial must be disclosed in advance. The reason I put this in here is because recently I've had trials where one party wished to introduce something and had not disclosed it. And so it ultimately went in by consent. So if you say these are all the documents we would like to put in, and the other party looks at them and says, okay, that's all fine, you can do those by agreed either exhibits at the beginning or agreed book of documents beforehand. When you bring forward a document, make sure you have a copy for yourself, the opposing party, the witness, and the one that you wish to file for the court. Too often I end up without a copy to look at. And while the witness certainly needs one, if you don't bring enough copies, it's unfortunate if the judge is the person who you want to actually accept the document and they can't see it. So put the document to the witness. Ask them to identify it. What is it? Did they prepare it? Where did it come from? Why did they have it? After it's identified, then ask the court to enter it as an exhibit. Then ask the questions about the document. Again, frequently I will have this is a text exchange between me and my wife. Okay, great. It was on this date. I'm the green bubbles, she's the blue bubbles. Okay, great. And then they file as an exhibit, and then there's nothing else said about it. And I'm left wondering, well, why am I reading this text exchange? So the only thing I said here is the obvious exception would perhaps be a tax return. That's my tax return. It says what it says. But if you have people that you're trying to impute income in a family context, or in any civil matter, if you're trying to suggest that perhaps someone is earning income, that you want to maybe go through that tax return. Next slide, please. So self-represented parties are a challenge for both the court and for the lawyers. My best advice for you is to attempt to manage them in the same way you would deal with opposing counsel. The correspondence needs to be respectful in the courtroom. Refer to them as Mr. or Ms. When do not take advantage. The court has an obligation to ensure a fair process, and don't abuse a self-represented party. If you're making an objection, make it to the judge hearing the matter. Let the judge manage the situation. I have certainly seen unfortunate circumstances where an exchange starts to occur between two lawyers or between a lawyer and a self-rep. So this is just keep your question or your objection to the decision maker and allow them to manage the situation. I know all of this is easier said than done, especially if you have a self-rep who's filling your email inbox and your voicemail. But it seems to me that it only brings the legal profession into disrepute if you fall to the level of abuse. So there's nothing wrong in my view with papering your file in such a way that you have advised the self-rep that you will only respond to one email every 5 days. Unless, and your client and the self-rep need to learn to parent together potentially. How would you manage your own client? So I think that these things are easier said than done, but I feel that particularly in the trial context, ensuring that you've made all the right disclosure, that you are addressing them in a respectful manner is still very important. Even if you are frustrated with them and they have made your work on this file very difficult over the months leading up to the trial. Next slide, please. So I think that we all have different strengths and weaknesses. I think that if you write beautifully, your strength is your written advocacy. So don't save it for your oral argument. I have certainly been in hearings where one lawyer had beautiful written material and the others was okay. There was nothing wrong with it, but you were more persuaded by one than the other on the written document. And then they came into court and one of them was obviously more persuasive in oral advocacy. And it sort of essentially leveled the playing field. But so if you're a strong oral advocate, that's great, but you should still don't miss the opportunity to file a brief. Know that it is the opportunity to put forward your case. It doesn't have to be eloquent necessarily, but it should be complete and it shouldn't be a missed opportunity. It is read in advance. I have been involved, I was involved for years with the Canadian Bar Association, and I certainly have friends who practice law in different parts of Canada than I do who don't believe that the judges actually read things in advance. And if you were practicing in a very busy center and the judge has a docket with 50 matters on it, they may not have been able to read everything in advance, but I know that they will have tried very hard. And so your oral advocacy can be, your written material is very effective. And if you know that the judge doesn't have a lot of time, then I would suggest then this is your opportunity for your brief to be brief, right? Lay out the issues succinctly, lay out your main points. I know I've said to be as, provide as much information, like not to hold things back, but using that written advocacy skill effectively.
Oh my God.
Hello? So next slide, please. I previously talked about paying attention to the judge. I have repeated some of those facts here. Don't ignore questions. Pay attention to what the judge is doing. Don't interrupt the self-represented party who's clearly not being effective. You're not doing anything but making yourself look like you're not prepared to allow for the matter to be heard fully. Sometimes the most effective way to ensure that something actually comes to a close is just to let the self-rep have their say. I know that I sometimes forget that myself, but just letting it go. Let the judge guide you. Did they say you have your point? Move on. Did they ask a question? Answer it. If they stop taking notes, ask for direction. Do you like me to address a different issue? Do you have my point on this issue? But it's also okay to push back. I've certainly had situations where I have asked the lawyer specific questions about, and they have said, this is why I think that this is the law, or I don't agree with the conclusion you're reaching based on the law. But it's also important to have the case law or the legal narrative to support the argument that you want to make. If the judge saying, well, in this case, this is the law, and you don't have cases to that are different, that dispute that interpretation, you may make yourself look foolish by just continuing to push the point. Final slide, please. So in conclusion, I just want to say advocacy is not dead. It is important at trial, but it's important at motions, settlement conferences, and any interaction on the file. Advocacy is not hostile or aggressive. It's effective and strategic. Always remember what your case is about and make your case. So those were my comments about advocacy. They're obviously of a more general nature, but I think that there are some excellent texts that certainly were recommended when I was in law school. The practice of law doesn't shift that dramatically. And so old advice can still be good advice, even though it may seem dated. Are there any questions or any issues that you would like to discuss that have come up in cases that you've been working on? You can either type them in the chat or share your. There are none, Rebecca. I'm not sure.
I actually had a question about self-reps, and you had mentioned the idea of letting things go. I imagine there were boundaries on that though, like with respect to I hear there's a value in having them be heard, but did you want to comment a little bit about how that where that ends?
So I think that when I was speaking about that specifically in my mind, I was thinking about in their closing argument. Sometimes they just want to say their piece and move on. Obviously, if they're testifying and everything they're saying is opinion or hearsay, I would absolutely object. I am going to, I'm not going to disagree with you. Like, the reality is that the evidence that they're giving is the information that I have with which to make a decision about the issues before the court. If someone in their argument is talking about how sad everything has made them feel, that's not relevant, but I'm not necessarily going to say that they can't say what they would like to say in their opening or closing argument. And so that's the distinction that I would draw, is making sure that the evidence meets the rules of evidence, but argument is often, even for lawyers, a more passionate plea to the court that the court's not necessarily going to agree with, but may allow to proceed. There's a question on the materials from today available. I believe that the PowerPoint is available.
Yes, it will be posted online shortly after the session, if it hasn't already been.
Yes, and I apologize for any typographical errors. Those are my own.
Okay, I don't see any further questions in the chat. Thank you very much, Justice Horst, for being
Very
here
welcome.
with us today, and greatly appreciate it. Valuable, and the presentation will be available online, and also the recording of this will be available online, so people can either watch it again or they can tell others who weren't able to be here today that they have the opportunity to view the CLE. So thank you again for your time and for your sage words for our lawyers here in Nunavut. Thanks.
You're very welcome. It's my pleasure.